Hello everyone, welcome to ProTalent and I'm Nitin Parmar. My dear students, today we are going to discuss about one of the very important part for our current affair. I'm sure when you are preparing for CLAT, you are aware that current affair is one of the very crucial part. Today, I'm going to discuss about some crucial aspect. So when we are going to learn about this current affair, we are not just learning the facts, but we are also learning various concepts about the human institutions, concepts about governance, concepts about law. That's what we are going to learn. At the same time, we are also going to learn certain important words. Okay, I'm sure you understand that learning important words are very crucial for your examination, because if you prepare well for your vocab, I'm sure you will prepare well for your entrance exam. Okay, let me start with the first point for the day. So the agenda, what we have is, you can say today's news item. In today's news item, if I share information with you, then it says that restore speech in full. That is what Rahul Gandhi tells to Mr. Om Birla. So we all know Mr. Om Birla is the speaker of 18th Lok Sabha. Yes or no? अभी इलेक्शन हुआ था and after that election this guy got elected. Rahul Gandhi was giving some speech and that speech was expunged. Okay, so that's a word called expunction. Okay, so his speech was expunged and there is expunction. Okay, so he made his first speech as a leader of opposition, okay, in Lok Sabha, and that was expunged. Okay, some portion was expunged. Now, what is the meaning of expunged? Expunged refers to the removal or deletion of certain part of the speech, okay, or certain part of record. You want to remove certain thing. That is, you can say, a kind of expunge. So for example, CLAT consortium brings out a paper and within the paper there are certain questions which are wrong. Okay, then they will expunge the paper. I hope it is very clear. Great. Okay. So in this context of the passage, Rahul Gandhi is blaming Mr. Om Birla for expunction. Okay, so that's an official record में से ये चीजें निकाल दी है ना? That is how the idea is. So he says it is against the very tenets of the parliamentary democracy. Now we all understand that parliamentary democracy is the system what we follow. Okay, so there is a democracy that is by the people, for the people, of the people. And then there is a concept called parliamentary democracy. What happens in a parliamentary democracy? The people who are elected by the, you can say, citizens, they are the people who will be, you can say, running the country. That is a parliament. Okay, so parliament comprises of three things. One is Lok Sabha, second is Rajya Sabha, third is president. Okay, so Lok Sabha, Rajya Sabha and president makes parliament, and this parliament is governing the entire system, and this person says that it is against the tenets of parliamentary democracy. Now what are the tenets of parliamentary democracy? What are the fundamentals? What are the principles? Tenets means principles. Principles of parliamentary democracy requires that a free speech. Okay, so there is a proper, you can say, free speech, and when someone is giving speech in the parliament, there is immunity. There is absolute immunity. Okay, please note this argument, note this point. I will come back to this point when I am going to discuss something about USA. Okay, so what is I am going to discuss? Wait for some time, but what I am going to tell right now is, it is the principle of parliamentary democracy, that is the member of parliament have absolute privilege. I hope it is very clear. Great. So when they have absolute privilege, okay, they can speak anything. Yes or no? He argued that, you can say, when Mr. Anurag Thakur's speech was also inclusive of the kind of argument I made, and his speech was not expunged. My idea is expunged, and he says I am constrained. to state that the portion expunged do not come under the ambit of Rule of 380 of Parliament, and what I sought to convey in the House is the ground reality and the factual position. That's how the argument he can make. Okay. Every member of the House who personifies collective voice of the people whom he or she represents has the freedom of speech. That's the tenet of, you can say, parliamentary democracy. So if, let's say, one candidate is represented by the population, okay, by the people of the country, that person has a freedom of speech, okay, in the parliament. Okay, so that is enshrined in article number 105, 1, that is subclause 1 of the Constitution of India. Remember, the member of parliament gets freedom of speech not under article 19, okay, but under article number 105. Okay, because that's a different, you can say, position. I hope it is very clear. Great. So the idea is expunge. Okay, he said it is a selective expunction. Selective expunction means removing parts of a speech or record which is partial in manner, biased in manner. That is the word called selective. Okay, I hope it is very clear. Great. Let's move forward and talk about another important news item which is coming from the, you can say, Bombay High Court. Bombay High Court, you can say, is you can say hearing a contention about one very important unit which central government of India started, which is known as fact check unit. What is fact check unit? What does it do? So when we are living in this internet world and in the world of social media, people are creating a lot of content, and when they create a lot of content, there are possibilities that people may also create content which is fake. And when there are fake contents, who will check it? Okay? The fake content has to be checked by some unit. So what happens? It is self-regulatory system in today's time. What happens in self-regulatory system? Okay, if there is something wrong, something which is factually error in the information, people will take video, people say, oh, this is right or not, they try and search on their own, and then they find that is wrong. Okay, but then it may possibly end up creating a lot of trouble. For example, during this 18th Lok Sabha election, there was a kind of message which was flowing in India that if you are not voting in this election, if you are eligible to vote and still you are not voting, 350 rupees will be deducted from your account. That's the kind of message was spreading. There was no law, there was no rule made like it, but there was message that Election Commission of India is sending such kind of messages. Please go and vote. That's the kind of messages were coming. That's a fact check unit. The work of fact check unit is to do this kind of checking. Okay. So these fact check units are part of Information Technology Rules 2021. Rule 3, Clause 1, Subclause B5 allows government to establish a fact check unit to identify fake, false or misleading information about its business on social media. Okay. And then there are petitioners. Petitioner like Mr. Kunal Kamra, they filed petition challenging this rule, saying that this is not appropriate. Okay, whatever the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021, within that, such kind of unit is not acceptable. Okay. Now, why are they putting such kind of argument? Let's understand first the defense of the union government. And a union government is represented by the generally Attorney General. In this scenario, Mr. Attorney General ki jagah par it is Solicitor General. Solicitor General Tushar Mehta, just a minute. Do you know who is the India's Attorney General? If you know it, please put that into comment box. Okay? If you don't know, please immediately search and identify. Okay? I'm sure you know he is Mr. You can say Venkatramani, R. Venkatramani. Anyway, coming to Solicitor General, he is the law officer. Okay, he is the second law officer. The first law officer, that's a lawyer for union government, is Attorney General. Similarly, there is Advocate General for state. Okay, that's an official lawyer. So Solicitor General Mr. Tushar Mehta argued that FCU, which is fact check unit, prevents the, you can say, spread of false information, fake information, and maintains that the right to know and not to be misled is as important as freedom of speech. So if you have a freedom of speech, that's wonderful. There is no trouble to that. But at the same time, if you have a freedom of speech, you must have a right to get right information. Okay, that's a very simple thing. What are the examples of FCU? State government like Kerala and Uttarakhand, as well as certain private firms, they have their own fact check units. Okay, fake news incident, I've just informed to you about Election Commission. They said 350 rupees will be deducted from the voters' account, those people who have not voted. Okay, that's the kind of problem which are coming up. Okay, and that's the kind of problem which are coming up. Now, what is the argument? Possibly by Kunal Kamra. And what is he saying? Mr. Kunal Kamra is saying that, look, this fact check unit is not legal. Okay, this fact check unit is not legal. Center doesn't have right to do it. Center doesn't have any right to do it. And while Solicitor General Mr. Tushar Mehta says, we, that is government, are not the final arbiter here. Just like individual, government can also intimate. Okay, the FCU is a methodical way of doing that, and being a statutory regime, it has consequences. We are not arbiter. Okay, the first arbiter is the intermediary, the final arbiter is the court. Okay, and right to be informed correctly is necessarily inherent in article number 21. That's what we are going to do, is what they said. While Mr. Kunal Kamra says, look, this is going to be wrong. This is going to be bad, because fact check unit will be utilized as creating chilling effect in the mind of the people. People will be in a position to get affected by this fact check unit, because at the end of the day, if it is a government's information, government will check the fact according to their own way. You understand that there is a biasness by the government. There has to be fact check unit as an independent body. It should not be under the executive's regime. So when it is coming under executive's regime, it may end up getting, you can say, biased, is the argument coming from, you can say, petitioner. What is your viewpoint? Do you really agree that the fact check unit should come under the control of executive and executive should carry out this activity, or should it be an independent body? What is your take on it? Okay, please tell me in the comment box. Okay, great. Moving forward to interesting, you can say, statement made by our Chief Justice of India. Our Chief Justice of India, D.Y. Chandrachud, he is 50th Chief Justice of India, and he has been putting some good comments. Okay. One of the earlier comments he made was, please do not treat court as a temple. It is not Nyay Mandir, and the judges are not the gods. Yes or no? Judges भगवान थोड़ी है, और ये न्याय मंदिर थोड़ी है, ये तो कोर्ट है भैया. ठीक है, बड़े अच्छी तरीके से उन्होंने ये बात रखी, because otherwise people will start believing that these people are God and this is मंदिर, और इसके अंदर ये नहीं हो सकता, वो नहीं हो सकता. The people who become deities, and constructively deities, and will become, you can say, very rigid about their system. Then they are not interpreting the law. They think what they say will become a law. Yes or no? So that's a problem. Okay. So here, Justice D.Y. Chandrachud, he said courts should bow to the might of no authority other than the Constitution. He says courts are subservient only to the might of the Constitution and no other authority. Court should be independent. Court should not be subservient to any other authority except the constitution. ठीक है, very important point. My dear students, as a student of law, you must understand a concept called rule of law and rule by law. Such kind of ideas, such kind of statements clearly tells us a clear understanding about rule of law. We are governed through rule of law. So what happens in a rule of law? There is a law and people are governed through that rule of law, not rule by law. People are not governed through by the help of law, but there is no one who is governing us, but there is a law which is governing us. Very important one, very important one. Okay. So here he says the courts have to be independent. How do we get courts independent? Okay. One is we put in the constitution certain system by which court will become independent. Second way will be, you can say, telling judges and the courts to not to become subservient to some other authority. Yes or no? For example, in our constitution, there are three ways we make our court independent. One, while appointment of judges. Appointment of judges, there are no role of legislature or no role of executive. Number one. Number two, while the service of the, you can say, judges, their service cannot be altered. And number three, their removal, they cannot be removed by executive or legislature, but there is a method available which is known as, you can say, impeachment. Okay, so that's one. Okay, so that's an independence. But otherwise, okay, sometimes the leader of the court, that is CGI, must also come out and tell their judges that, look, you are a judge, you are a, you can say, the protector of justice, you are a protector of constitution, so you are deriving your authority from the constitution. So constitution is above you, but no other authority is above you. That's what they have to be careful about. The courts are, you can say, structurally and philosophically, they are, you can say, very important for our country. Their integrity has to be maintained and they should not cater to any power. They need to focus only on one thing, that is constitution. Okay? So courts are not just symbol of sovereignty, but it is also vital public service provider. It is not just that authority, but it is servant to people. Very important point is talking about, I believe, such kind of, you can say, thought processes are really in need of the hour, and that is what our Chief Justice of India is helping us. Moving forward. Purchasing and selling, thereby they are manipulating share prices. Okay? This is what they put a blame. Then SEBI put a committee to investigate that matter. ठीक है कि भाई exactly क्या हुआ, चलो देखते हैं. Now SEBI is accusing this Hindenburg Research, which is a kind of short selling company. It says you have colluded. कल्यूड करना, दैट मीन्स एसोसिएट होना, ग्रुप बना, कोलैबोरेट करना, बट फॉर अ नेगेटिव एक्टिविटी. सो दे कल्यूडेड विद यूएस एसेट मैनेजर किंगडॉन कैपिटल मैनेजमेंट KCM to use non-public information to set up a short bet against Adani Group. So Hindenburg, you were colluding with Kingdom Capital, and thereby you created a situation where a particular company's share prices will go down and you can enter into short selling. Hindenburg said this is nonsensical. This is an attempt to intimidate and silence us. And there is a show cause notice provided by SEBI, Securities Exchange Board of India. That's a regulator for stock market in India. The SEBI के जो head है, that is the chairman of SEBI, is currently you can say Madhabi Puri Booch. Okay, so 46 page का शोकॉज नोटिस उन्होंने हिंडनबर्ग को दिया and 5 other entities including Kingdom Capital, a Mauritius based fund set up by Kotak Mahindra Bank. So what is this bank involved in? ठीक है, first understand what is the potential you can say penalties. So they may face monetary penalties and they may have to return whatever the illegal gains they might have gone through. So initial allegation by Hindenburg says that the Adani is accused of improper business dealing leading to significant drop in Adani's market value which later rebounced. ठीक है, तो इन्होंने बोला कि अदानी इज इन्वॉल्व इन इम्प्रॉपर बिजनेस डीलिंग. सेबी ने स्पेसिफिक एलिगेशन लगाया. सेबी ने कहा हिंडनबर्ग प्रोवाइडेड किंगडम कैपिटल विद अ ड्राफ्ट ऑफ इट रिपोर्ट ऑन अदानी बिफोर इट पब्लिश फॉर द पब्लिक. ठीक है, एंड देयर बाय द मार्क किंगडम, द ओनर ऑफ किंगडम कैपिटल, ठीक है, ही सेट अप के इंडियन अपॉर्चुनिटी फंड KIOF, ठीक है, टू ट्रेड अदानी स्टॉक बेस्ड ऑन दिस इंफॉर्मेशन. ठीक है, तो किंगडम कैपिटल ने एक फंड ही बना दिया और वो फंड ने अदानी के ऊपर काम करना चालू कर दिया. Yes or no? मतलब this Hindenburg had, you can say, a kind of motive to do something wrong. That's what SEBI is saying. ठीक है, in nutshell, primarily. So KIOF repeatedly created short positions. That is what SEBI says in Adani stock between January 10 to 20 in 2023, 5 days before the Hindenburg report came out. ठीक है, that's what SEBI says. So SEBI might have done good work. ठीक है, उन्होंने बिल्कुल सर्च करके इंफॉर्मेशन निकाली है. कोटक महिंद्रा बैंक का इन्वॉल्वमेंट क्या है? SEBI claims that Mauritius registered unit of Kotak Mahindra Bank manage an offshore fund used by Hindenburg's investor partner to bet against Adani, which means it is involvement of one of the bank in India. SEBI alleged that this position were closed in February, resulting in $22.25 million gain. Hindenburg claimed it made $4.1 million in gross revenue from its Adani short and $31,000 from shorting Adani's US bonds. So they said, we did not get so much of money. We got only this much money. Kotak Mahindra said that, okay, Hindenburg has never been a client of the firm. We don't know. Okay, whatever we did is on our own. There is no collusion. There is no involvement of Kotak Bank with Hindenburg or with any other. Okay, so whatever we have done is from the general information which is available in the public. We have not misused any information. Interesting points. Yes or no? Okay. Now, the point which I mentioned, that please focus on the word immunity while we were discussing about the first point of Rahul Gandhi. Okay. Here we have a case coming from SCOTUS, which is Supreme Court of the USA. SCOTUS. From there, this news is coming, which is about criminal immunity for Trump. Okay, and let's understand what is Supreme Court ruling here. Okay, Supreme Court of the USA, that is called SCOTUS, they said that there is absolute immunity for presidents. Okay, presidents have their absolute immunity for criminal prosecution concerning their core constitutional power. So when a president of America is doing official work, and during that official work, whatever he does, he has complete immunity. Yes or no? That's what the Supreme Court is saying that. Okay, protection of official acts. President's official acts are protected from this criminal prosecution. That's very crucial. Okay, that's very important, because if you are not providing such kind of protection, such kind of immunity to president, to the executive leader, what will you do? Will you be in a position to carry out work in a right way as a president? No, and therefore this is important. Okay, so the ruling is going to benefit obviously Trump, ठीक है, he is facing a lot of charges. One of the big charge he is getting on those 2020 presidential election के दौरान he created a lot of problem. Trump is accused of making false claims about the election being stolen, leading to January 6, 2021 Capitol Hill attack. है ना, he said कि elections are stolen, they are rigged, and thereby huge attack took place. Lower court rejected this idea, and now the higher court, that is Supreme Court, is giving this immunity. That's very important, and that's what the immunity is all about. In India, president has immunity. Yes or no? In India, president has immunity while he's doing his work. Okay. Similarly, absolute immunity lies with member of parliaments. Yes or no? Great. And then the speech by Rahul Gandhi, where he talked about Abhay Mudra. What did he talk about? Abhay Mudra. Okay. So let me discuss what is Abhay Mudra. Okay. That's very important. Abhay Mudra, okay, because it's a part of culture. CLAT may ask questions on GK. Abhay Mudra is also known as fearless gesture. It symbolizes protection, peace, and dispelling any kind of fear. The word Abhay is derived from Sanskrit word called fearlessness. The gesture is associated with providing reassurance. The commonly seen Hindu, Buddhist, and Jain iconography about this gesture. So originally ये gesture कहाँ से आया? ठीक है. So संस्कृत में मुद्रा term आया, which is about seal or a mark or a symbol or a currency. Many times in Buddhist context, ठीक है, it refers hand and arm gesture during the course of ritual practice. That is how the idea is. Mudras are commonly associated with the visual depiction of Buddha, you can say religion, and this is known as Buddha Rupa. Different gesture conveys different mood of Gautam Buddha. Okay. 500 years after Buddha, who lived in 6th and 17th century BC, the person of the great teacher was not depicted with the form of an image or sculpture. At Sanchi, for instance, the Buddha is symbolized by, you can say, vacant throne or just a footprint. So there is no Bhagwan ka symbol. Earliest depiction of, you can say, Buddha, it says that it's in a physical form is quite, you can say, connected to the first millennium. Depiction started appearing in Gandhara art form. So before Gandhara art form, there were no such kind of depiction of Buddha. Okay, so in Gandhara art form, it all started. Gandhara art form is very famous in Pakistan, Afghanistan. Okay, us jagah se. So earliest depiction in Buddha Rupa, which are 4 mudras. One called Abhay Mudra, that is depiction of fearlessness. That is one. Okay. Dusra is, you can say, Bhumi Sparsh Mudra, that is earth touching gesture. Okay. And then you can say Dharmadhikar Mudra, which is gesture of will of Dharma, or Dharma Chakra Mudra. Okay. And Dhyana Mudra, that is a gesture of meditation. So ये 4, you can say, mudra है. Please आप उसको ध्यान रखिएगा. Okay? चलिए, great. ठीक है. So I hope today's session is comfortable with you. आज आपको मजा आया होगा. अगर आपके मन में कोई क्वेरी हो, कोई क्वेश्चन हो, तो मुझे कमेंट बॉक्स में बताइए. I will be more than happy to respond to all your queries. ठीक है. Till then, don't miss out to like this video, subscribe our channel, and tell to large number of people to be part of Pro Talent. Okay? Thank you. Have a great day.